Welcome back to the deep dive. Today we are opening a case file that feels like a logic puzzle designed to really break your brain.
It is.
We're stepping into the world of tort law to tackle a problem that pits two huge legal concepts against each other. The
Yeah.
really strict rule of contributory negligence versus the, I guess, more humanitarian doctrine of the last clear chance.
It's a fascinating area because it forces the court to answer a very uncomfortable question. If you break the law and get hurt because of it, do you just get nothing?
Right.
Or does the person who hurt you still have some responsibility to save you from your own, bad decisions?
Exactly. And we're looking at a classic, almost nightmare scenario today. A pedestrian crosses the street illegally jaywalking in the dark. They get hit by a car. Now, the pedestrian was clearly negligent, but what if the driver saw them? What if the driver had, say, 10 or 12 full seconds to stop, but didn't? Who pays them?
To answer that, we're going to dissect the landmark case of Dickerson v. Martin. It's the perfect vehicle to understand this conflict because the timeline of the accident really splits the liability in a way you might not expect.
So what's our roadmap for this deep dive?
We have a very specific analytical path. First, we need to establish the baseline, the strict statutory duties of a pedestrian. We need to understand exactly what contributory negligence looks like the second you step off a curb.
Right. And once we've established that baseline,
Then we pivot to the exception, the last clear chance doctrine. We'll break down exactly when a chance to avoid an accident is considered clear versus when it's just, speculative.
and you're using other cases to do that?
Yes, 3 different precedent cases to see the difference. And finally, we'll synthesize all of this into a 4-step checklist you can use to analyze any autopedestrian accident fact pattern.
Perfect. Let's jump right into the doctrine then. Before we even get to the specific facts of Dickerson, let's talk about the pedestrian's duty. In the eyes of the law, if I decide to cross the street outside of a crosswalk, what's my specific legal obligation?
Okay, so the general rule here comes from a Kentucky statute, and it's reinforced by the case, Music v. Waddle. The rule has 2 distinct elements.
Okay.
First, every pedestrian crossing a roadway at any point other than a marked crosswalk must yield the right-of-way to all vehicles.
Okay, yield to cars. That seems pretty standard. What's the second element?
This is the critical one from Music v. Waddle. The duty to keep a reasonable lookout is continuous.
Continuous.
It doesn't end when you step off the curb. The court held that the street itself is a danger area. Therefore, a reasonable person has to maintain that lookout until they have completely cleared the street.
So you can't just look once, decide you're safe, and then sort of tune out while you're walking across.
Precisely. The moment you enter that danger zone, your duty to look is active and ongoing. If you stop looking, you are failing your duty.
All right, let's test this rule. We're going to open up the case file for Dickerson v. Martin. So let's analyze Dickerson v. Martin regarding the pedestrian's behavior. First, what are the legally dispositive facts regarding the plaintiff's actions?
Here's the situation. The plaintiff, Martin, was an 18-year-old high school student. It was about 7 p.m. in December. He decided to cross South Seminary Street mid-block to get a neighbor's mail. So not a crosswalk.
Got it. The street itself.
It was 24 feet wide.
Did he check for traffic before he went into the road?
He did. He stopped at the curb. He looked left. It was clear. Then he looked right and saw the defendant, Dickerson's car. Martin estimated the car was about 550 feet away.
Okay, so he sees the car, he does the mental math and thinks, I have time. What does he do next?
He starts walking at a normal pace.
Yeah.
But here it is, the crucial fact that this entire first issue turns on. Martin admitted under oath that after he stepped off that curb, he never looked back to check the car's progress.
Never.
He walked the entire width of the street without looking right again.
Wow. He just assumed he was safe based on that one single look.
Exactly. He walked blindly until the instant of impact.
Okay. Looking at those actions and what we just discussed about the duty of care, what was the core legal issue regarding the plaintiff's conduct?
The issue was whether Martin was contributorily negligent as a matter of law.
What does that mean as a matter of law?
Essentially, were his actions so obviously negligent that the trial court shouldn't have even let a jury debate it? Should the judge have just declared him negligent right then and there?
And what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied that rule from Music v. Waddle about the statutory right-of-way. It breaks down into 2 elements. Element 1, presence in the roadway outside a crosswalk, what the court calls the danger area.
Okay.
And element 2, failure to maintain a continuous lookout.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, presence in the danger area?
Right, so the sub-issue here is simple. Did Martin enter a zone where he was required to yield? And the application is straightforward. He knowingly crossed mid-block, not in a crosswalk.
So under the statute.
Under the statute, that makes the street a danger area where vehicles have the right of way. So the conclusion is easy. The first element is met.
Understood. Now, what about the second element, failure to maintain continuous lookout?
Okay, so the sub-issue here is, did Martin satisfy his duty of care by looking only once? And the sub-rule, which comes from music, is that a reasonable person would take a second look as they proceed across a known danger zone.
And how did the court apply that to Martin's specific actions?
Martin himself admitted he walked the entire width of the street, all 24 feet, without checking on that approaching car again. He just assumed he could make it. The court reasoned that a reasonable person would have checked the progress of a car they knew was coming. Because he didn't, he failed the duty of continuous lookout.
So element 2 was also met. His negligence was absolute. And after analyzing all the elements, what was the court's final conclusion on this specific issue?
The court held that Martin was contributorily negligent as a matter of law. The trial court had made an error by letting the jury even decide the question of his negligence.
So the judge should have just made the call.
The judge should have issued a directed verdict on that specific point. Martin was at fault.
Okay, let's unpack this. If Martin was negligent as a matter of law, if he violated the statute and walked blindly into traffic in a contributory negligent state, that usually means he gets nothing. It's game over.
In a strict contributory negligence jurisdiction, yes, that would absolutely be the end of the story.
But it wasn't the end here. Martin actually won a judgment of over $12,000. So clearly there's another mechanism at play that allows a negligent person to still win. This brings us to the second major concept. What is the last clear chance doctrine?
This is the pivotal exception that saves the plaintiff's case. The general rule is this. Even if a plaintiff is negligent, they can still recover damages if the defendant had the last clear chance to avoid the accident and failed to exercise ordinary care to do so.
Last clear chance. Those words seem very specific. It sounds like there's a really high bar for what counts as a chance.
There is. The courts are very careful here. It can't be a speculative possibility, like we see in the case Severance v. Sohan.
And it can't be.
It also can't be a situation of concurrent negligence, where both parties have an equal opportunity to avoid it right up to the impact. We see that in Satterley v. Stiles. The defendant must have the final, actionable opportunity to save the day.
This distinction between a clear chance and concurrent negligence can get a little abstract. Let's try to ground this. Can you give us a visceral hypothetical to distinguish these scenarios?
Absolutely. Let's use the sleepwalker versus the sprinter analogy. This really helps distinguish precedents like music and Satterley from our case, Dickerson.
Okay, lay it out. What is scenario A? The sprinter.
Imagine a pedestrian dressed in all black, hiding behind a bush. Suddenly, they just shoot across the road instantly. The driver slams on the brakes, but boom, impact. This is very similar to the facts in Music v. Waddle.
Okay. In that case, the pedestrian is obviously negligent. Does the driver have the last clear chance?
No. The peril is momentary. The driver has no time to calculate, no time to react. The chance to avoid it is not clear. The driver is basically helpless.
Got it. Now, what is scenario B? The sleepwalker, which is the Dickerson scenario.
Now, imagine a pedestrian walking slowly, methodically across a well-lit street. He's visible for a long time, let's say 12 full seconds.
Well, seconds.
He's oblivious, maybe staring straight ahead like a sleepwalker, and the driver's approaching on a straight road.
In this case, the pedestrian is still negligent. I mean, he shouldn't be there.
True, but the driver has a clear chance. He sees the guy, he has 12 seconds to think, I should slow down, or I should swerve a little. The pedestrian's negligence put him in the road, but the driver has the final opportunity to prevent the tragedy. That is the last clear chance.
That makes perfect sense. It's all about who has control in those final moments. So, with that framework, let's analyze Dickerson v. Martin again, but this time focusing on the defendant, the driver. First, what are the legally dispositive facts regarding the driver's opportunity?
Okay, so the facts paint a very clear picture of time and visibility. First, the driver, Dickerson, was going 30 miles per hour. Second, the visibility was good. There was a street lamp right there, and the road was straight.
And what about the timeline? How long was Martin actually in the road?
This is the key fact. If Martin walked at a normal pace across that 24-foot street, the court calculated he was visible in the street for up to 12 seconds.
And the physical evidence?
There were skid marks for 140 feet, and critically, the impact point was just a step or two from the far curb. Martin almost made it all the way across.
Okay, so we have a long window of visibility and a plaintiff who is literally inches from safety. What was the core legal issue regarding the last clear chance?
The issue was the driver's chance to avoid the accident clear enough to submit to a jury? Or was it just speculative? In other words, did the evidence support giving the jury a last clear chance instruction at all?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the last clear chance rule. It involves 3 key elements. Element 1, the plaintiff is in a position of peril from which they cannot escape, or, of which they are oblivious. Element 2, the defendant observed, or should have observed, the peril. And element 3, the defendant had the time and means to avoid the accident. The chance must be clear.
Thank you. Now for the court's elemental analysis. Let's look at that second element, observation of peril. How did the court apply this?
Right, so the sub-rule is that drivers must exercise ordinary care to observe the road. The court then looked at the application. The street was well lit by an overhanging lamp. The pedestrian was in the street for a significant duration, up to 12 seconds.
So even if the driver claimed he didn't see him, the law says he should have.
Exactly. The conclusion for this element is that a jury could reasonably find the driver should have seen him in that lighting over that period of time.
Understood. Now, what about the third element, the clear chance to avoid? This is where the defense argued it was just like the music case, a sudden emergency.
Right, but the court completely rejected that comparison. The sub-issue here is, did the driver have enough time to react? The court contrasted this case with Music v. Waddle, where the pedestrian shot across, and Severance, where the peril was momentary.
And how did they apply that contrast to Dickerson?
In Dickerson, Martin was walking steadily for 12 seconds. The application here is vital. With 12 seconds of visibility and the plaintiff being only steps from safety, a slight swerve or hitting the brakes just a fraction of a second earlier would have saved him.
So it wasn't a maybe, it was a definitely could have.
Correct. The conclusion was that the chance was not speculative. It was clear.
And after analyzing all the elements, what was the court's final conclusion regarding the case as a whole?
This is the tricky procedural part. The court affirmed that the last clear chance instruction was proper. The jury should consider it.
But
however, because the trial court messed up by letting the jury decide if Martin was negligent, when he was definitely negligent as a matter of law, the case was reversed for a new trial.
So they have to do the whole thing over?
Yes, but the holding is very specific. The new trial must only submit the issue of last clear chance. The jury must be told, Martin was negligent. That is a fact. Now, you decide only if Dickerson could have saved him anyway.
That is a very, very specific instruction. It shifts the entire focus of the trial to just those final few seconds.
Exactly. It prevents the jury from getting confused and thinking, well, maybe Martin wasn't really at fault. It isolates the driver's final responsibility.
This has been a really rigorous breakdown. For our listeners who might be facing an exam question on this or just trying to keep it all straight in their heads, let's synthesize this. You mentioned a checklist earlier.
Absolutely. Think of this as your auto pedestrian liability checklist. If you see a fact pattern like this, just follow these 4 steps to get the right answer every time.
Step 1.
Step 1, the pedestrian check. Ask yourself, is the plaintiff outside a crosswalk? If yes, you strictly apply the continuous lookout rule from music. If they looked away while crossing, they are contributorily negligent, period. Lock that in.
Okay, that's first. Step 2.
Step 2, the timeline check. Calculate the duration of the plaintiff's presence in the road. You need to distinguish between momentary and extended. Was it a sudden dart out, or was it a 12-second stroll like in Dickerson?
And that leads directly to step 3.
Step 3, the clear chance test. If the timeline from step 2 is short and sudden, you cite Severance or music. There is no last clear chance. The driver wins. But if the timeline is long and the road is visible, you cite Dickerson. The last clear chance applies.
And finally, step 4.
Step 4, jury instruction precision. If you're writing a ruling or an argument, make sure the instruction places the burden on the defendant after acknowledging the plaintiff's negligence. It's all about the remaining chance. The jury needs to understand they aren't deciding if the pedestrian was wrong. We already know he was. They're deciding if the driver was the last one who could have fixed it.
That's a powerful takeaway. It really flips the script on how we think about fault.
It does. It essentially says that preserving human life is more important than being right on the road.
It's the ultimate aha moment here. You can be dead wrong, illegally jaywalking, not looking where you're going, and you can still win a lawsuit. Why? Because the other guy had 12 seconds to spot you and failed to hit the brakes.
That's the heart of it. The law demands that we protect even the negligent when the means to do so are clearly in our hands. You don't get a free pass to run people over just because they're breaking a rule.
A provocative thought to leave you with. How much attention are you paying to the danger areas in your own life? Because if you have the last clear chance to fix a mistake, the law, and maybe your conscience, says you have to take it. Thanks for listening to The Deep Dive.
Stay safe out there.